right, good morning, everyone. I'm Steve DeLaroche. I'm the Special Code Enforcement Magistrate for the City of Daytona Beach Shores, and these are code enforcement hearings. The way that we conduct the hearings is the city has the burden of proof. That means they have to prove that there is a violation by a preponderance of the evidence. You do not have to prove anything. The city can call witnesses. They can introduce documents, photographs, or any type of evidence they feel they need to prove their case. You have the opportunity to cross-examine any witness that the city calls. After the city has completed its case, it's your turn. You can testify yourself, you can call witnesses, you can introduce photographs or any type of evidence that you need to rebut the city's case, and then I will make a decision. If at any time you do not understand what is going on, please raise your hand and I will tell you your options. I can't help you with your case, but I can read the menu of choices that you have, and then you're free to choose any of the following options. And please only raise your hand if it's your case. If you don't understand what's going on in somebody else's case, stay afterwards and I'll explain what happened. The first item on the agenda is to approve the minutes of the January 15th meeting, which was the last time we had code enforcement. I realize that nobody else, except for the city officials, were here during that meeting. Does anybody have good cause as to why the meeting should not be approved? All right, seeing nobody excited about it, the minutes from the last meeting are approved. The first case on the agenda is case number 25-0009. It is property owner OC3711 LLC, 3711 South Atlantic Avenue, Daytona Beach Shores. Ms. Herstein? It's my understanding that this is going to be continued at the request of the property owner because of some sort of family event out of town?
Thank you, Your Honor. We learned yesterday that the owner was requesting a continuance. As you'll see in your packet, you do have emails from the owner stating that he is aware of the date and time of next month's meeting, and his commitment that if he is not able to make it, he will send an attorney to represent him or an authorized representative to answer questions that you might have. Based on the late time frame of that request, we are asking that the city be reimbursed continuation administrative fees in the amount of $97.16, and there is an affidavit for that in your packet.
Okay, and the next code enforcement meeting that this will be addressed is June 18th, 2026.
Yes, Your Honor, and that is specifically the date that the property owner has responded that he's aware of.
Okay, I'm going to agree with the request for continuance, order $97.16 in administrative fees be paid within 30 days.
Thank you, Your Honor.
Thank you. Okay. Only one other case on the agenda, that's Halifax Investment Services, LLC, 3225 South Atlantic Avenue, Daytona Beach Shores, also known as case number CDEF 2023-24. Is there a representative for the property owner? Mr. Pickens, how are you?
Posey.
Pardon?
Posey.
Posey, sorry. I apologize, Mr. Posey. Okay. And the gentleman seated?
The owner.
The owner, okay. Gentlemen, I know you look comfortable there, but I'd prefer if you came over here to the front row. That way you can see everything that's going on. If you have to object, leaping to your feet, I'll be able to see you as opposed to over there where you may be blocked off.
We'll be ready.
And did you receive a packet from the city?
Yes, I was provided it this morning.
Okay. And is this the packet that you submitted to me?
That's correct.
Okay. For your information, I have read every single word that you've submitted. I did that last night, as well as I've gone through the entire packet that the city submitted. Okay? Now, that doesn't mean they're in evidence. It means that I saved us a lot of time by not reading them while you all stared at me. Okay? So please govern yourself accordingly. All right, Ms. Herstein. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? And Lieutenant, we'll pick up you in that as well.
Yes, sir.
Okay. All right. Now, I note that the city clerk, who's usually here at the meetings, has the power to swear people in, but because this office is a constitutional office under Florida, I also have the authority to administer oaths. If anybody's curious, or if this comes up on appeal, this is the rationale for me doing it. Okay? All right, please proceed.
Thank you, Your Honor. I would like to ask that each of the documents included in this PowerPoint file, whether presented during the hearing or not by the city for this case, be accepted as evidence, most of which have been provided to the special magistrate, and all of which have been provided to the respondent's representative.
Okay, Mr. Posey, do you have any objection to them being received in evidence?
No objection, just noting that we received them this morning.
Okay. Do you need additional time to review them?
Not at this point.
Okay, because as you are well aware, they're requesting a fine of $135,500.
Yes, Your Honor.
Okay, and I want to make sure you have all the time you need to prepare for this.
I appreciate that.
Okay. All right. They'll be received in evidence.
Thank you, Your Honor. This is a second compliance hearing for a case that was brought into compliance, for a case that began on June 18th of 2023. Here are pictures, top picture being early on in the case, and the bottom picture being more recent, taken March 20th of this year. The majority of the violations were to the east side, so there's not much difference to see between these pictures. However, a lot of difference on the east side of the building.
Oh, definitely.
You can see now that the seawall is intact, at least visually intact as of that picture date, and also compliant by that date as well.
Is this property currently occupied?
I believe that they are open for business, yes.
Okay, all right.
Basically, an initial hearing took place October 19th, 2023. The property was found in violation at that time, and the property owner was given until April 30th, 2024, which was just over 6 months, to bring the property into compliance. In addition to that, they were required, the property owner, who is different from the current property owner, but the property owner was required to submit bi-monthly signed and sealed reports from a Florida state licensed engineer remarking on the safety and the structural integrity of the buildings on the property. Because
Okay.
they were undermined, there were concerns about the building staying in that state, so there were bi-monthly reports submitted, and those were submitted in a timely manner. You'll see 8 affidavits of.
I reviewed every one of them, and I'm
compliance.
impressed that they made every deadline,
They sure did.
because we don't see that very often.
Indeed. The compliance date of April 30th came and went, and the other violations had not been brought, most of the other violations had not been brought into compliance by that date. So a first compliance hearing took place on May 16th of 2024. Non-compliance was found by His Honor, and an order imposing fine and lien was imposed at that time and recorded. The property changed hands to the current property owner, Mr. Matwani, as the representative of 3225. I keep mixing up the property owner, the 3225 Daytona Ocean Investment LLC. And you probably came across in the packet a notice of sale and a notice of the property representative changing due to that notice of sale. So those were also sent to the property owner. Compliance was achieved for this property on October 24th of 2025, for which you see an affidavit in the record, along with, before I go on to that, I just want to tell you that a couple of these, like if you look at violation on the screen, you'll see that compliance was actually achieved, some of these by the next date, and it doesn't show that, but October 25th. But because we had gone on October 24th and done some finals, we were called back. Maybe we had, there'd been some miscommunication about doing all of the open permits and finaling them all out. So we went back on the 25th, and anything that became compliant on the 25th was also given the compliance date of October 24th. So in addition, most of these violations, almost all of them, could not become compliant until final approved inspections were done, able to be final approved, and in some cases, there were earlier inspections which failed. But because of that, all of the permits that are, the required permits that are relevant for this case are included in the packet. We can refer to them as necessary, but I didn't think that you would want me to go through every.
No, thank you.
As you shake your head. But they are here along with some pictures if need be. Otherwise, you have the compliance dates that the city has found before you between these two slides, 4B3 and 4B4. And we can go on from here. Ultimately, the city is recommending that you find either an order number 12 imposing the fine and lien at the full amount, or order number 13, which is for a rescission or reduction or full rescission of the fines, and that's at his honor's discretion. We are asking that in addition to the $99.33 unpaid for the first compliance hearing, that you impose today's administrative fee amount of $128.03 for a total of $227.36 in administrative fees, along with any fine that his honor deems appropriate.
Okay, thank you.
Thank you.
Mr. Posey, do you have any questions for Ms. Hursty?
Not at this time, no.
Okay. Lieutenant Metters, do you have anything?
No, sir, I do not.
All right, thank you. Appreciate it. Okay, gentlemen, would you like to say anything?
Just a little bit, just to
Okay.
give some context.
Before we start, like I said, I read everything that you submitted. One thing that I want to start with is, and I see that your defense is based upon largely the fact that you came late to the game, that this gentleman purchased the property, and you're seeking mitigation because of that. One thing that you did not include in the packet is, in order for your defense to even have any footing, I want to make sure that this is not the alter ego of the original corporation.
Understood.
Okay? Because it'd be a very easy thing for me to transfer the property, say, to my wife, and then she says, well, you know, I didn't know, or anything like that. So I want to make sure that we're not dealing with an alter ego before I entertain any of your mitigation.
Your Honor, that's correct, and I will even have the current owner testify to that fact. These are totally independent and separate parties. Obviously, folks that work in Daytona Beach Shores, there's some indirect relationships, but none to the extent that there's financial or anything that would qualify as an alter ego with the previous owner.
Okay, so none of the original ownership group is in the second ownership group?
Correct.
Okay. Sir, can I have your name?
Sure. My name is Jay Matwani with 3225 Daytona Ocean Investment.
Okay. And sir, would you mind raising your right hand and being sworn? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. I do not swear members of the Florida Bar. They were sworn in, and I consider that their oath is still sticking. So we don't swear in lawyers.
Absolutely.
Okay? Well, that's not for your benefit. Believe it or not, people watch this, and if there is an appeal, this record can be used on appeal. So I am explaining not for the people that are here that can ask questions. It's for the people that may be reviewing the record in the event of an appeal. Okay? All right. So based upon the testimony under oath, I will accept the fact that this is not the alter ego of the first ownership group, and let's proceed.
Appreciate your honor. And just to quickly touch on, again, we don't have very much knowledge as to the previous relationships and owners and their active pursuit of code compliance, but the things I do want to mention is that it was fairly well known that I think the current manager on the property prior to acquisition by my client, it was very, very difficult with the city, and you know, of course, personal opinions play into it and how they manage the code compliance, but part of what I hope to at least make your honor aware of is that this gentleman, knowing that fact, wanted to jump into this and try to solve the problem for both the city and also for just the issues that were on the property. The other thing I wanted to mention is that they did have a contract or two that we're aware of, and again, I do not know the background other than to say that attempting to secure permits and inability to close out permits, it's clear from the record provided that there was some attempts in trying to work that out. I can't speak to the specifics, but that inability, I think, as you can see from the record that we submitted, shows really how much effort this current owner went through to make this happen within 150 days. Through a full site plan, several permit pulls, very extensive and detailed permits. That's a monumental task, and I don't want to talk out of turn with how the other owners approached all of this, but had this, I think, been reversed and this gentleman was been able to fix this issue day one, it would have been fixed. And the other things I wanted to mention, I think that there was, I'm sure that...
Would you like your packet and evidence so that what you're speaking about I can consider?
Yes, and the packet that was presented to you, if we could submit that into evidence, and, we don't have any modifications to it, so.
Does the city have any objection to the packet?
No,
Okay.
Your Honor.
Then it'll be received into evidence. I know it seems a little silly because I've already reviewed your evidence as opposed to generally in court, the evidence isn't reviewed until it's in, but to save time. But I can't consider it unless it's there. So, all right, now that it's there, I'm well aware of everything that you're speaking of, and let's continue.
Really, that part of, you've, I'm sure, heard this before, that when you're talking about code compliance, you're really trying to encourage the right thing. And the right thing here is to bring it into compliance and get an owner that's going to look at the public good, trying to do what the right thing is for the city. And I'm not aware of many situations, like you pointed out, that you had a gentleman who or achieved all compliance deadlines when he was at the reins. We would appreciate if that was taken into consideration. I think from the perspective of the city, that if you, it would send a message that wouldn't be well received to others if having an owner who in good faith jumps into something with such expeditious, trying to tackle these issues so proactively, that still being punished with a fine based on those good faith actions, that's, I don't think that serves any party, I guess is what I would say. And of course, the prior owner's business is the prior owner's business, but other than that, the only thing I wanted to add is if you have any specific questions for my client, he's aware of more of the nuanced details of how proactively he reached out to the city, all of the outreach that he did, even maybe just his efforts on trying to get the previous owner to do the right thing. He's happy to opine on those points too.
Okay. I do have a couple of questions, if you'd like to put your client on the stand.
Yeah, of course.
All right. Sir, I appreciate the fact that you bought a distressed property and you've made it usable, because certainly the city doesn't want distressed properties rotting on the seashore next to something that is viable and reducing the property values and the sight lines. In going through this, have a question. Was there a price reduction in the property because it was distressed and the fines were potentially being hung over the new owner's head?
Yeah, that's a great question to ask. To be quite frank with you, due to the extensive amount of work that I put into the property and the repairs, I mean, it's subjective. I don't feel that the price that I paid after the money that I put in really put me in a much better position moving forward, to be honest with you. There were some underestimated things that went down in this construction, and also this approvals that delayed it, that I wasn't aware that would need to be done. So I think I paid a fair price for it, to be honest with you. I don't think that I got the reduction that I should have gotten for the property, considering the time and effort we put into it.
Okay, I understand. If you buy a car with a dent in it, it's not the same price as a car without a dent, and so the price is generally reduced by the amount that it would take to fix. Okay. Gentlemen, just give me a second, okay, because I've got mathematics to do. Mr. Posey, I am not deaf to what you're saying as far as your client taking a distressed property and bringing it up to what the code requires, and honestly, what the community in the Shores expects property to look like. I have your requested credit calculation. Some of it I'm going to take into consideration, some I'm not. I did neglect to let the city cross-examine your client based upon what I asked him. I'm going to let them do that if they're interested, and then I've got an answer for you. Ms. Herstein, do you have any questions?
Thank you, Your Honor. Just briefly, because I wasn't exactly sure what was being put on the record regarding permitting. I know that in the packet, 41 days total appeared to be reduced for total turnaround time for permits. Is that correct?
Are you asking me?
Either of you.
One of the things that we found out here was that this property required a new site plan approval for the rear entrance and the backside of the property. The property was severely damaged by a hurricane, and when the seawall went down in the pool, obviously the landscaping and everything went with the property. And I'm speaking out of concept. I've done a few other repairs in this town. I'm a property owner in the Shores, and I really like the Shores, and specifically only the Shores. And I never had to go through such an extensive site plan approval. So what ended up happening was the backyard had to meet its pervious, it had to meet all its square footage calculations, it had to meet a tree every 500 square feet, it had to meet a certain type of tree, it had to meet a certain type of egress. It was just a full-blown administrative review which had to go through all departments, life safety, electrical, building, et cetera. I was not aware of that when I purchased this property. I was aware there was going to be that extension. So what I'm saying is I think I submitted on July 10th is when I submitted their first round for the administrative review. And I think it got approved on August 20th, if I'm to be correct. So please don't hold me to that. You guys have the record. There was some revisions that were required to go through that. So with all due respect, but that is, I think that those days is what we're requesting. The calculation of the 41 days.
Yes, and the question then is page 4B-57 in the packet that you were presented. That's the one that you gave us. Do you have?
What page was it?
4B-57. Just to make sure that we're on the same page, and it appears that we are, but I wasn't sure when you were discussing permitting, it made it sound like there might have been some egregious permit times. And for example, our records actually show that from July 10th, your initial application, middle of the page, the application was completed July 29th, and then the approval date for this development order, August 20th, very similar to what you said, 22-day turnaround for that site plan. And then similarly, I think you were requesting 41 days total for building permit reviews total. And just as an example, on 4B-51, we're showing something similar, that the longest permit that I could find took 20 days to turn around and issue. And I just want to make sure that we're on the same page, because there were many in this record, like 4B-43, that shows 0 turnaround days, that they were issued on the day they were applied for.
Understood, and I think to clarify and maybe use your example that you had brought up about the car with the dent, I don't think the car with the dent was expected to also have an engine failure. And that was part of the issue on our side, and I think when we're talking about permits, I don't think it was intended to say it was a literal turnaround from city to application. 41 days, I think, was more of an estimate trying to take into account the time it takes to reach out to these consultants, to get them turned around, to get them engaged, trying to get them communicating with the city. So it wasn't intended to be a reflection on a delay on the city's end in any way. It was just, I think, doing this for a living, that this was quite a expeditious turnaround from both sides, given what typically is involved in terms of site plans and permits. 41 may be a little bit of a misnomer, but it was a good faith attempt to try to calculate what he thought was a fair estimation of what a credit would be due for that.
Thank you for that, Gordon.
Let me make sure that I've got this. Building permit 25-1166 was description of work, install wood beach access stairs at rear of property. Date applied for August 18th, 2025. Date issued September 10th, 2025. That's the longest running permit that I noticed in this. Was there a longer running permit?
There was also the administrative review for the rear entrance, for the rear, yeah, there was, and Gwen, I apologize, it's a total, first I want to say I agree, I think the city was great, they worked excellent with me. I don't believe there's delays, but they have, everyone has to cross all their Ts and dot all their Is. A concern that had come up with was the stormwater. In that review, I had originally submitted on 7/10/2025, administrative site plan was submitted. And this is the one I'm speaking about in particular, but there's multiple, sir. There's multiple permits. That permit, when I submitted it, granted, the package may have not been completed until 7/29/2025, according to the city's record, but that permit was then issued, administrative approval granted on 8/20/2025, in my submittal of my timeline. Answering your other question, you asked about the rear steps. When you're working, obviously, as you know, in the coastal construction line, there's 3 municipalities that are involved, or 3 different governing agencies that are involved. It's the City of Daytona Beach Shores, it's Volusia County, and it's also FDP, Florida Department of Environmental and Protection. I had also secured those permits from FDEP for the stairs. I had to get those from.
Right, I saw you got a turtle waiver, which
Correct.
surprised me.
Thank you. I got a turtle waiver, was able to work during that time. And then I actually can't even submit to the City of Daytona Beach Shores until I secure the FDEP permits. So I had secured those first, and then obviously I had to come back to the city to get the city permits, because I need all municipalities, and also the city won't approve it unless all 3 other 2 municipalities were included before they can submit to their third. So yes, there was some review that had gone back and forth. To be honest with you, again, not on the delay of the city, but things come up. There was a post that was approved by FDEP that didn't meet current building code. So the plans that FDEP approved for the post were not approved by the City of Daytona Beach Shores. Now, it's hard to say who's the governing factor here, and I didn't want to get into to that, but we had to have an engineer redo the plans and change the post from a round post to a square post so that the city could approve the plans for the steps.
How many days did that cost you?
Significant amount of time, probably 3 weeks.
So 21 days.
That's correct.
Okay. All right.
I have no further questions, Your Honor. I just wanted to
Okay.
make sure we were all on the same page with the permitting. Thank you.
All right. Gentlemen, the fine is, as you know, number of days times the amount of the fine. And while I can appreciate the sentiment, it's a math problem. So if you'll give me a second, I want to make sure that I give you credit for every single day, because it's $250 per day, and let me come up with a number.
I appreciate that.
Okay? All right. There it is.
client had one piece of information he wanted to.
Okay, by all means.
Thank you, Your Honor. I just want to mention, in the packet, you reviewed it, I don't need to go through it extensively, as you said, you've seen it for the record. I just wanted you to notice, in the last 3 or 4 pages, I only put 3 permits in there specifically, rather than attaching the file with every single permit. 3 of the permits that I had supplied with were, 2 were replacement permits, one for a concrete repair, and one was for a fascia repair, where if you look at those 2 permits, it says replaces permit X so-and-so, and the other one says, it's only the last 3 or 4 pages of the packet. There was 2 permits that Peck and Associates, who was the GC at the time, had. Whether it was issues with the construction or the work, or whether it was an issue with the owner, I don't know, I can't speak for that, but I aggressively got in there and removed contractors who were not performing the job in a timely fashion. And that takes a little bit of discussions with local contractors where they get a little upset about their production or their progress. But I did that, and also I attached one more permit in there, which was to rebuild the 85-foot retaining wall below the building.
Right, I see that permit.
You notice that permit. That permit was issued the day after I closed, which was May 29th. A very extensive permit cost, and it was like $2,000 just for that permit, just for that one that permit. And the reason why I bring that one up is my work began during the due diligence phase. I mean, I had already submitted to FDEP. I had already submitted to local government agencies prior to my ownership, prior to me even closing on the property, due to the understanding of how long some of these administrative reviews and these times take. So the day after I closed, I hit the ground running. I mean, it wasn't as if, we were trying to secure. So when you look at the record and you look at this coastal construction permit that was submitted back in April, it was submitted under Halifax, under my direction as a GC to get these permits in place. So I just want the record to reflect that my proactive approach, was started prior to even closing, and that there was absolutely 0 time lost in this. I don't truly think, unless you have someone who's a construction manager, a GC, a hotel operator, permit expediter, I just don't think these type of things could happen in the fashion that it did, and I just wanted you to respect that as you're considering the time and looking at, after spending $600,000 to be tagged with another $150,000 fine, I just don't feel that's fair for me.
I did not pick up on the point that this happened so soon after the closing, and I completely and sincerely appreciate that. Let me see if I can figure out how to put that into the math, okay?
Thank you.
Okay. I'm going to order order number 13, which is the order containing reduction and mitigation. The reduction and mitigation is follows. I'm going to give you the 21 days that you're requesting for site plan preparation and engineering, the 41 days based upon permitting, inspection, scheduling, and government reviews. Ordinarily, I do not give credit for overlapping periods. For instance, if you are waiting on one permit, but you already have another permit, and work should be progressing on the permit that's been granted, I don't view it that the wait on the second permit actually penalizes you because you have something to do. However, because of unique initiative taken by the new ownership group, I'm going to waive the rule that I have regarding overlapping permits and give you the full credit for the 41 days that you're claiming. I'm also going to give you 16 days for federal holidays. Weekends during active construction, I ordinarily don't give that because I don't know whether or not your contractor is working during that period of time, and just getting a weekend when there's actual work being done, I generally don't give. But again, because of the unique circumstances and the speed at which the new ownership gave and the effort into this property, I'm going to give you all your weekends. That's 154. Now, the last thing, and sir, I'm not going to pronounce your name because I don't want to mangle it, but I appreciate what you did and what you're saying. And ordinarily, it takes a new ownership group 30 days to get up and running. So I'm going to give you 30 days additional credit. So what I'm giving you credit for is 262 days. That reduces the fine from $135,500 down to $70,000. I know I'm not eliminating the fine entirely, but essentially I'm cutting it in half by giving you all of the time you need. Now, in addition, since I'm fining you $70,000, I know this little money doesn't matter, but it actually does. You owe the city $99.33 for the previous hearing and $128.03 for this hearing. That's $227.36. I'm ordering that to be paid within 30 days. Can you do that? Okay.
The fees or the total fine?
No, the
The fees, I have no problem with.
fees, $227.36. Now, sometimes the city will make a deal with the fees, or the fines, if you pay them early. I'm going to leave this order open till the end of the week to see what you can do as far as dealing with the city regarding the fines.
And just to be clear, Your Honor, I didn't mean to interject, but, so the 70,000 moving forward would be at the discretion between the applicant or the respondent and...
Well, it's not at the discretion, and I'm not really sure how this happens, but on previous times, the city has come to me and said, if they pay this immediately, would you be willing to reduce the fine further? And I have. I'm not saying that they're going to do that. I don't know how that happens. Ms. Herstein may know. I don't want to know, okay? But I'm not going to sign the order for a week. I'll give you a chance to talk to them.
May I clarify the record?
Sure.
Okay, so at this point, the property owner, Mr. Matwani, has the possibility and the opportunity to pay $191 and submit an application to go before the city commission, and that is the only possibility for further reduction. There is not any kind of an agreement behind the scenes or otherwise. It's on the record.
But to be clear, I think Your Honor is giving us the opportunity to have that discussion for the next week, and we'd love to entertain that. Of course, nothing may come of it, but...
That's the only possibility at this point for reduction. My suggestion to address both what you're saying and what you're saying is that you simply reduce it and not tie the reduction to payment within a certain time frame. Or if you do, you tie it to payment within 2 years.
Well, 2 years would be nice, but it is a judgment, so it does accrue legal interest. So it's up to you when you'd like to pay it. But it is $70,000 plus $227.36. Only the $227.36 is due within 30 days.
Understood. And then if I'm understanding correctly, Your Honor, then there's no opportunity for discussion over the next week?
Not with me.
Well,
I do not know.
Understood.
Okay, then the city's saying no.
Understood.
Okay.
There are times prior to a purchase that the stipulated agreement is obtained. That was not done in this case. That it is tied to specifically to property development in a certain manner, and it's not a tool that's available at every point. However, at this point, where we are now and where we were months ago, the only further opportunity for reduction is to go before the city commission. It is their lien. They specifically give the special magistrate one opportunity to reduce in our code, and then it is their lien, and then you have one opportunity to request further reduction from them.
And just for the record, was this made known to the current owner?
Indeed, it is, the opportunity to go before the city commission?
No, the opportunity for a stipulated agreement.
That is not an opportunity that's available in most cases.
I understand, but was he made aware of this fact?
I can't answer that.
And
It's not something
that's city
that comes
dealings,
from our
not-
code enforcement office. That doesn't work like that.
All right.
Well, one question, Your Honor. Thank you very much. And first of all, I appreciate everyone's time here, and I appreciate your time. Just out of curiosity, thank you for your calculations. You were generous, and I appreciate that. Do you not give any hurricane delays for Hurricane Helene and Hurricane, we had 3 named storms during that time. We had Milton, and we had Hurricane Helene, and those were in my calculations. Those are state mandated orders.
And just for the record, too, those emergency orders, if I recall correctly, expired March of this year. So we've been under an active emergency order for both of those hurricanes.
Okay, did the emergency order prevent you from continuing work on the site?
Well, again, that would cause us to speculate. Typically, hurricanes cause delays for any owner. So-
Right, I agree. I don't remember what happened during these 2 storms, whether it just rained and blew or if they actually did anything. I don't have any testimony, if you'd like to reopen it, to explain to me what happened during those 60 days and how it prevented you from continuing to develop the site. I might give you a couple more days, but you can't just say, I grew up north. A snow day could be a snow day or not. It depends on where you lived and whether you got snow. I don't remember independently what happened during these storms, and I certainly didn't stop by your construction site to see what was going on. In fact, I'm not even allowed to do that. So if you'd like to tell me more, maybe I can help you.
Sure. During my discussions with the prior contractor and the prior owner,
Oh, I remember why I didn't give it to you. This is during the prior ownership period. So I'm sorry, I'm not going to consider those because it had nothing to do with you.
well, it did in a sense, and I'll tell you, they said
Okay.
the flashing and the soffits got re-damaged again, and that's why those permits were not closed. So there was a bunch of this going on when I got involved into the project, between PEC and between Mr. Gary Cohen, who was the property manager at that time. Also, some erosion and more undermining started happening at the property, and water slides between the 2 properties caused more erosion to happen. So there was a significant amount of this going on. Predominantly why the property still wasn't in compliance the day that I purchased it.
I understand. I'm just not going to give you any credit because it was prior to your ownership. All right, thank you though, gentlemen. 70,000 is the final number.
May I point to one that partially answers the question that was asked previously, and I said I don't know, but I would
Sure.
like to point to page 4B-80. This was an email follow-up to a verbal conversation that Mr. Matwani and I had, I believe, on the 1st of March. This was before purchase of the property. I followed up because it was a long conversation and it had important details in it. I followed up with this email, full conversation about what happens to the fines. He was considering purchasing it at the time, is what he expressed to me, and he wanted to know if the fines would automatically be reduced. And I shared with him the process and exactly how he would proceed or could proceed to purchase it, but there was no guarantee. I do specifically say in here, guarantee of any reduction.
And just for the record, there's no mention of the stipulated agreement process nor any opportunity.
It's not a code enforcement, typically a code enforcement, a function of the code enforcement office.
So I understand. I'm just pointing out that none of those facts were pertinent in the order of reference.
Okay, I understand.
It's not a function of the code enforcement office. It's not initiated by the code enforcement office, Your Honor.
I understand. All right, gentlemen, thank you very much for your time.
Thank you.
Okay. I've been presented with 4 different copies of the agenda, and I keep looking at them to make sure that they're all the same. I don't see that we have any more cases. The next code enforcement special magistrate meeting will be June 18th, 9 a.m. in this building, then July 16th, and then August 13th or the 27th, depending upon which date the city settles on, because I will be playing golf in Scotland that month, and we will not have the normal third Thursday.
I've heard from all parties except one that the August 13th date would be acceptable, and I am expecting to hear from the final entity that it matters to, that August 13th would be accepted. I'll let you know as soon as we know. But
All right,
it
well,
sounds like August 13th.
I appreciate the city moving it for me. Just tell me how many tins of shortbread I need to bring back to pay for the variation.
Again, that is at your discretion.
Lieutenant, you got anything?
No, sir, I do not.
You just got tired of sitting and wanted to be closer to what was going on?
Just to
I see.
soak it all in.
Just get some camera time.
Yep.
All right.
He was prepared to present, but that case fell off the agenda, so.
They were afraid of you. All right, well, thank you, everybody.